This map highlights where state level protections exist for LGBTQ individuals. And so it's largely the West Coast, not Arizona, but Hawaii does. Then we have Minnesota, Iowa, Illinois, Wisconsin has some limits in that um, it only protects LGB, but not transgender. And you can see the entire East Coast, and more states are passing it now. But I think, and certainly with Bostock, the federal protections will trump any of the state protections at that level. But that's so you're aware. The next um, the next page will have the names of the states, but basically speaking, that's the states that have protections. As noted in the previous slide, this is just the physical list of all the states and protectorates, and the cities and counties, of course, are included here. As you can see at the bottom on the right-hand column, of all the states that either protect sexual orientation or protect gender identity. This graphic also addresses pre-Bostock LGBTQ population issues. Number one, 47% of the LGBTQ population live in states prohibiting employment discrimination, and that shouldn't be uncommon. People will start to flock towards states. We're flocking towards states where they could be protected. I know I did when I was looking for work. If I could avoid it, it was really important to me to avoid living in a state where I was going to be discriminated against. 7% of the LGBTQ population live in states explicitly interpreting existing prohibition on sex discrimination to include sexual orientation or gender identity. So not only if they don't have some of those states very explicitly said our sex-based laws, our sex discrimination laws cover sexual orientation or gender identity. So 7% of our population lives there. 2% of the LGBT population lives in states prohibiting employment discrimination based on sexual orientation only. So there's only a few states that cover sexual orientation and not gender identity. 44% of LGBTQ population lives in states that do not prohibit employment discrimination based on orientation or identity, including 5% LGBTQ population living in states that preempt local non-discrimination laws. So there are some states where the state laws prohibit the local laws from being able to um, have non-discrimination clauses on the books, which is kind of sad, honestly. If you are a public sector employee, there are certain protections, obviously executive orders and things of that nature, but really primarily the First, Fifth, and 14th Amendments have some privacy rights attached to the discrimination claims, making sure that we are protecting people's privacy. What they do in the privacy of their home has no reflection on their ability to do their job at the federal level. There are some state constitutions with similar protections, but not all. But it provides that same sort of basis of the right for privacy in the work that you do and what's going on in your private life, and it doesn't have an impact on that. And the case Weaver versus Nebo and Romer versus Evans are included in your textbook. Some closely related claims have to do with the gender-based stereotyping and dress codes and things of that nature. The EEO stance now on mixed motive cases, of course, which is what Hopkins was about, but also the important thing around gender-based stereotyping, that women and men both experience different kinds of double binds, if you will. Women face a double bind when they are told to act more feminine, be more feminine, wear jewelry, talk with a quieter voice. They're being told they're too macho, so that they need to be more feminine in order to be able to be taken seriously in the workplace. And then when they act masculine, like Ann Hopkins did, when she transgresses that and she acts more masculine, like that she was expected to do, then they have problems with that. But then when she acts like a woman and she's more feminine, and then she doesn't get protected by that either. So it's kind of this catch-22 in that it's what we call a double bind. Males have the same experience. When they are acting more feminine, they're not considered to be real men. And as ridiculous as that sounds, and then for when they act more macho, then they are told that they are too aggressive and too assertive and that they need to be more like women. So these whole things around gender-based stereotyping, men get damaged by this as well. And it is important to just let people express themselves the way they want to. And I love that we see nowadays people like Billy Porter and other individuals who are comfortable, men who are comfortable wearing dresses and being who they were meant to be, straight or gay. And I think that that's completely fine in my book. But I know not everybody agrees with me. But why can't a man wear a dress? Why not? I don't have any issues with it. If it makes them happy, that's good. So generally, as much as I have my own bias, of course, in the way that I am thinking about and present this information, the most important thing that you should take away from this chapter is really the text's purpose is not to convert people to believe one way or the other, but to respect and understand that someone's ability to do their job is not necessarily related to their sexual orientation. That if someone has the essential skills and knowledge and abilities to do a job, their private life is of no relevance to people, and it doesn't impact their ability to do their job. And it's okay for us to be a little uncomfortable around things that are different from us. One of the things that we know about implicit bias and implicit associations is that the more that we familiarize ourselves and are exposed to people who are different from us, the more comfortable we become with differences. We learn, we grow, we understand, and we start to become more comfortable. And I think that's the big takeaway, right, from this book, is that recognizing where the law is at on these issues, and that we are seeing trends changing towards more acceptance. And regardless of your personal feelings about it, we don't have the right to interfere with someone's ability to get married, to have a job, to make an income, just because of who they love or how they identify. With respect to sexual orientation as a basis for adverse employment decisions, we know that now post Bostock, it's going to be very interesting to see how this plays out in terms of workplace policies and how people who are more conservative around these sorts of issues may work hard to try to limit Bostock's application or to express that religious freedoms are being impinged upon because someone is expressing themselves as LGBTQ. There are still many, many people that I know of personally who I know are LGBTQ, but choose to remain closeted regardless in their workplace, that they do not let people know what their identity is. That there are a large majority of employers have inclusive policies, but not a lot of small ones. So if you're working for a small one in a small town in the middle of nowhere, your chances of having having protection under the workplace policies is fairly slim still, even with Title VII protection. So it's going to be very interesting to see how this evolves, and I'm hoping with the next edition of the textbook we have some good news to report. A lot of the issues that they're going to face has to do with their workplace status, their relationships, their workplace conduct and conversations, what they can and can't say, what kind of dress codes are relevant, and if someone is transitioning as a transgender individual, what are their rights in terms of being protected, in terms of bathroom rights, in terms of their ability to express themselves in their intended gender, and how they want to express themselves, and add in the complexity of things like gender non-binary, and people who are gender queer, who don't follow any particular pronoun. They like to use they or she or z or anything along that line. How do we address that in the workplace, particularly how we want to be referred to? And that's why it's important for people who are cisgender, which means that our gender identity is in alignment with a gender assigned at birth, that we use our pronouns and say, I'm Robin Berkeley and I use she, her pronouns. And it normalizes the idea that not everybody has pronouns that are easily observable and easily identifiable, and that we need to respect the pronouns that people choose to have used. It's important that we recognize this. So it, when you're looking for a job and these are issues that are important to you, they signal a company that cares about gender identity, that cares about diversity related issues. And you certainly don't want to be working in a workplace, if you can avoid it, that doesn't allow for those protections. Some pre-Bostock litigation had some really inconsistent rulings, like, for example, the DeSantis versus Pactel case, sexual orientation was not considered covered. But 2015, the EEOC started to make some changes, reasoning based on the reasoning of Hopkins around gender stereotyping, and on Colley, which was about same-sex harassment. And it just said they really started to interpret that those cases created precedent and extended application beyond sort of the obvious ruling that and so if we're already arguing that same-sex harassment can occur and that stereotyping occurs, and then there was some talk that Ann Hopkins was probably a very butch lesbian in what she was doing, and that created the issues for her, along with the stereotyping that engaged there. So again, 2015 is when the EEOC started to interpret it that way, but the law in and of itself, regardless of how the EEOC interpreted it, the law was abundantly clear at the Supreme Court level that same-sex harassment, because of DeSantis versus Pactel, was not covered under Title VII until the Bostock ruling. And there's a bunch of other ones: Hively versus Ivy Tech, Altitude Express versus Zarda, Evans versus Georgia Regional Hospital, et cetera, et cetera. These are all important cases in that process. So the Bostock case tried to resolve basically all the different rulings under the Courts of Appeals to make it all make better sense. So this is not relevant for small employers, right? So because Title VII argues that if you have less than 15 employees, full-time equivalent employees, you're not protected. If you're working in a small business that has 3 employees, you're not protected under Bostock. So this is why in a very specific Equal Rights Amendment, ENDA, Non-Discrimination Act, for the employees is relevant. And so we want to make sure that we have that, so even small employers are obligated to not discriminate based on sexual orientation.